All right. Can you tow a suspect's vehicle from inside the garage? All right. So some background. I don't know where this officer is from, but that's okay. So the background here is we had an incident last week regarding a pursuit of a reckless driver. The driver was seen by multiple witnesses parking inside a residential garage. We conducted call-outs and eventually arrested the suspect. A protective sweep was conducted and the vehicle was found parked inside the closed garage. The owner gave us permission to tow the vehicle. However, many question if the owner did not give us permission to take the vehicle, would a warrant be the only way to tow the vehicle from the garage? Great question. Let's walk through it. First, guys, my name is Anthony Bandiero, attorney and senior legal instructor for Blue to Gold law enforcement training. So, doing a little roadside chat from Rapid City, South Dakota. All right. So, first of all, okay, we got the call out situation that has its own implications. Generally speaking, when you surround a house and you call people out, it's you're seizing the person under the Fourth Amendment because they can no longer be free from government intrusion. So that's fine, but it's certainly easier to justify a surround and call out than it is a entry into the home. But I would like, if I was digging deep into this case, I would like to know why are we actually, doing a surround and call out on a reckless driver, just as a conversational point. Obviously, we're good all day getting a warrant. We're good all day trying to knock and talk and get this person to come out voluntarily. However, if they didn't come out and they didn't want to play ball, I'm just not 100% convinced that doing a surround and call out is the appropriate constitutional response. The next thing is, all right. Okay, so he did eventually come out and was arrested. The next thing the officer says, then a protective sweep was conducted. There are alarm bells going off in my head left and right now. And why are we even in the house, right? Why are we doing a protective sweep on a guy for reckless driving? I just don't see it. These facts, obviously, this is, a paragraph of facts, but I want everybody to think about what's going on here. Protective sweeps, entering a home when you're not even in the home, in order to do a protective sweep, is a Fourth Amendment intrusion onto the home. And we better have a reason that officers or the public or somebody in that house has a safety issue, like right now, right? We don't get to go into a home just to make sure that we're okay. Does that make sense? Like, this is an intrusion. So I would like to know what the officer would have articulated to the judge about why that protective sweep, that entry, was lawful. I have had plenty of people run from me, and we found them at the house. Rarely can I think of a time when I've actually gone into the house to do a protective sweep for a drunk driver, a reckless driver, and so forth. So that's the second concern that I have. Third, we saw the vehicle inside the closed garage. Okay, let's presume, for argument's sake, that the court is cool with why the cops are in the house, that this is a lawful protective sweep. Now we see the vehicle. Can we take it without a warrant? The answer is no. Well, I guess I said that too fast. Okay, so there could be an argument under plain view seizure, right? If you are lawfully present and you see contraband, evidence, fruits, or instrumentalities of a crime in plain view, you are allowed to grab and go, right? So I guess that is a good argument. I would just be very careful because the U.S. Supreme Court, kind of gave us a little pushback on seizing vehicles that were in curtilage. But that facts were a little different. That was Collins v. Virginia. That's where the police had probable cause that the motorcycle was stolen. They see the motorcycle on the side yard, curtilage, went onto the curtilage, seized the motorcycle, and it gets suppressed because you can't go onto people's curtilage to simply seize evidence, right? You would need actually exigency, not just the motor vehicle exception. So if in this state somehow that car is going to be seized under law, we don't, where I worked in Nevada, we ain't seizing cars for reckless driving, right? So I just have to, why are we seizing that vehicle? And if we want to get into it and searching, I definitely know we cannot search the vehicle, right? Because you would have to make another constitutional entry in order to grab that evidence to go into a vehicle that is not, and so forth. So I don't know that part. I don't know how we get into the, why what are we going to tell the judge about why we went into that vehicle for probable cause, and how's the vehicle evidence? So my advice, if I was the, lawyer on the phone with the cops asking me what should we do, I would be like, A, why are you trying to seize the vehicle? And B, okay, you sold me on that. If you can't get consent, let's go get a warrant. All right. That's what I have for you. I hope it helps, guys. If it does, and at least pushes the needle even a little bit towards some comprehension and some making good case law, hit like, subscribe, comment below, and I hope I've helped you get it right every time. That's my goal. All right. Until next time, my friends. I'm out.